Good evening, everyone. We are going to begin. Thank you so much to this panel called Carbon Markets and Human Rights, Preventing Negative Impacts under Article 6. This is a particularly timely panel, considering one of the major outstanding issues that we're looking at in negotiations at this time is what's happening under Article 6. That is particularly true for 6.2 and 6.4, which are the market mechanisms under the Paris Agreement. This year, we've seen several new pieces of research talking about the voluntary carbon market mechanisms, which were really highlighting, once again, the human rights risks that we're seeing with these mechanisms, as well as the often failure to actually provide any climate benefits. And we'll hear about one of those really important pieces of research from Judith in just a minute. This experience, though, and this research has once again raised scrutiny, though, about what's happening in these Article 6 negotiation rooms and what's going to happen with these market mechanisms when they're operationalized and the risks that poses both to communities, to the climate, but then also they're connected to the Paris Agreement, which creates new questions. We have a really excellent panel to discuss the really important work being done to try to protect human rights as these market mechanisms go forward and what the risks are. So first, I'm going to turn it over to Judith Lacknick to present their research.
Thank you, Kelly, and hello everyone, and thank you so much for being here. I would like to start this side event by telling you about the carbon offsetting projects of the French company Total Energy launched in the Republic of Congo in November 2021. It is a large-scale tree plantation named Bakassi for Bateke carbon sink, located on lands traditionally used for agricultural activities like cassava cultivation and gallery forests that were also used for the hunting, foraging of forest products and medicinal plants by indigenous people and farmers. Our organization, Caritas France, with our partners, CCFD Terre Solidaire and Justice and Peace Commission of Congo, investigated on this project, collecting testimonies of local communities and indigenous people. We also met the companies that implemented the plantation to have a better understanding of all aspects of the project. We conducted 13 missions on the ground and had regular exchanges with the groups of people who were impacted. We can identify 3 categories of people affected by the project. Firstly, the landowners possessing either land title or customary use rights. They have lost their lands as well as the income from their agricultural activities. A second group of people affected are the farmers who grow cassava and now face a loss of their livelihoods. And finally, there are the indigenous people who have been banned from accessing the forest, whereas they depend on the forest for their livelihood and income. Now I have presented the context, I would like to give the floor to our partner who alerted us to the consequences of these projects and coordinated the work we carried out with the local population.
Je suis Brice Makosso, je travaille pour la commission Justice et Paix de Pointe-Noire au Congo-Brazzaville, partenaire du Secours catholique. Mais parce que déjà, ce n'est pas la bonne solution que nous recherchons pour le réchauffement climatique. Ce type de projet viole les droits de l'homme dans des espaces de non-droit comme les pays du Sud. Au Congo-Brazzaville, nous avions suivi le cas du projet Bakassi qui est développé par Total Energy pour compenser le carbone. Et nous avons vu que ce projet a des impacts négatifs sur les propriétaires terriens qui ont perdu l'usage de leurs terres. Le projet Bakassi, évidemment, est l'exemple de projet d'accaparement des terres qu'auraient pu utiliser les agriculteurs pour l'autosuffisance alimentaire, pour la souveraineté alimentaire des populations. Le projet Bakassi de Total Energy s'est développé sans au préalable consulter les propriétaires terriens, les agriculteurs et les peuples autochtones qui ont perdu l'usage de leurs terres. Le genre de projet Bakassi qui se développe au sud est une forme d'injustice nouvelle qu'apportent les multinationales qui s'accaparent les terres des paysans pour compenser des émissions de carbone généralement réalisées dans les pays du Nord. C'est une fausse solution à partir du moment où nous ne pouvons pas nous rendre compte à quel moment l'arbre va pouvoir être capable de compenser le carbone qui a été émis plusieurs années avant, alors que l'arbre lui-même va prendre du temps pour grandir et pouvoir séquestrer du carbone existant déjà plusieurs années avant. Cette solution de plantation des forêts pour séquestrer du carbone est également une déresponsabilisation des multinationales qui peuvent continuer à émettre des gaz à effet de serre sans pourtant décider de réduire l'empreinte carbone de leurs activités. En fait, c'est un permis de polluer qui est donné aux multinationales qui peuvent, au lieu de réduire l'activité des fossiles, mais poursuivre cette activité tranquillement et tentent de compenser par la plantation des forêts, alors que les études montrent très bien qu'il est difficile de compenser du carbone qui a été émis plusieurs années après par des plantations d'arbres. La COP28 devrait réguler ce marché des carbones afin que les droits humains soient pris en ligne de compte dans le développement de ce genre de projet. Il faudrait alors édicter des règles robustes pour pouvoir contraindre les multinationales à respecter les droits des populations locales, puisque ce genre de projet se développe généralement dans les pays du Sud où les problèmes des droits humains sont déjà existants et difficiles à surmonter. Nous attendons que la COP28 régule le marché des carbones, mais qu'il mette également en place un mécanisme de gestion de griefs robuste afin de permettre aux populations impactées par ce type de projet de revendiquer leurs droits.
Thank you. So as Brice explained in the video, local communities reported a sense of injustice regarding the way the project was presenting to them. The attainment of the free and informed consent, the FPIC, a critical step for any project with potential impacts on indigenous people, remains pending. According to the latest information we had, the company just released the free and informed consent in the last of October 2023. However, according to the United Nations guiding principles, these consultations should have taken place when the project was launched, not 2 years after. So the project has been implemented without taking into account the need of people. In this respect, it is worth noting the forest access restriction also prevented indigenous people from reaching their cemetery located within the project area. They were forced to look for another burial site for their deceased and use palm leaves as a substitute for coffins. They told us they felt very humiliated by this situation. On top of that, it appears that no compensation plans for displaced individuals have been implemented and no impact study on the environmental and social risks of the project has yet been published. So now I've explained the impact of this project on people. We can ask what the company has done to remedy the situation. And sadly, not enough. Indeed, local communities have not been asked to participate in consultations regarding compensation for the damage caused by the loss of agricultural activities. According to information collected, landowners claimed that they have not been fairly compensated for their expropriation, and one of the 10 families identified has still not received any compensation to this day. As an economic alternative for the local population, the allocation of 2,000 hectares of agroforestry has been proposed. It could be an interesting alternative, but only 1 hectare of agricultural area was offered to each farmer, regardless of the size of their original landholding. It means that a farmer who previously owned 300 hectares of exploitable land could end up with only 1 hectare for agroforestry, which obviously looks very unfair. On top of that, the lack of training and awareness regarding agroforestry, which is very different from the local farming practices, may explain the skepticism among farmers concerning the productivity of this model for cassava cultivation. Moreover, the company highlights the significant social co-benefits of the project, especially in terms of creating new jobs for indigenous people. However, based on our conversations with the populations, only 17 indigenous individuals were hired in March 2023. And the lack of employment opportunities was a real source of disappointment, especially among young people from indigenous communities who had hoped to secure jobs with this project. And last but not least, we should also mention the lack of grievance mechanism, another critical tool. The company only implemented a complaint mechanism in 2023, but it did not allow those affected to assert their rights without fear or retaliation. Individuals could choose to send a letter or text messages to the company, which raises concerns about the confidentiality and the ability of certain populations to use this mechanism, as some of them are illiterate. To conclude, I would say that all the negative impacts I have just described should remind us the risk to people's rights and sovereignty that carbon offset projects can generate when there is no regulatory framework to protect them. Thank you for listening.
Thank you, Judith, to you and to Bryce for bringing this really important research to light. And it has a lot of the same patterns we've seen in a lot of places about a lack of notification and a loss of land and the lack of compensation. To share more, we are now going to turn to Gertrude Kanyangi from the Women in Agriculture and Environment.
Thank you. I hope it's on now. Yes. Okay. Yeah, thank you. Yeah, thank you very much for the opportunity. I'm pleased to be discussing a subject that's very close to my heart, coming from Uganda and working with a forest age community. Uganda is implementing a RED Plus project. RED Plus primarily aims at the implementation of activities to reduce human pressure on forests that result in greenhouse gas emissions at the national level. We are doing it in partnership with the Forest Carbon Partnership Facility of the World Bank through National Forest Authority, the government arm managing forests. The Uganda National RED Plus strategy and action plan had conditions for implementation. And the conditions were that they should have extensive consultations with the stakeholders. And there should also be assessment of the causes and drivers of deforestation and forest degradation, none of which was done. And they were supposed to be guided by, may I have the other slide, please? They were supposed to be guided by the Cancun safeguards. The Cancun safeguards fall under 3 categories, just to remind ourselves. For those of you that are not familiar with the Cancun safeguards, there's governance, where you are required to implement any project to do with carbon trading, consistency with national objectives and international agreements. And there should be transparency, effectiveness, effective forest governance, and sovereignty. Then there are social safeguards, respect for knowledge and rights of indigenous peoples and members of local communities, and full and effective participation of stakeholders. If you look on the right side of the slide, you will see who the stakeholders are. And we protest the use of the term stakeholders because it assumes that there's equal power relations. But we demand that we be addressed as rights holders and the others as stakeholders. Because we don't just hold a stake, we hold a right to the natural resource. And then the third category of safeguards was environmental. Natural forests, biological diversity, and enhancement of benefits. We are required to address the risks of reversal and reduce displacement of emissions. Next slide, please. So what were the challenges that we ran into as we entered into this uneven relationship, as we attempted to implement a project where we're supposed to be partners? What challenges did we run into? The evidence that we have is that there were gross violation of human rights in pursuit of carbon trading. It's another form of neocolonialism where local communities are exploited. For instance, very much like what Judith has just submitted, there were no extensive consultation whatsoever, only token consultation with technocrats and urban-based briefcase civil society organizations. No one bothered to go to the forests, to the ground, where the rubber hits the road, to give correct info and bargain with the rights holders. The indigenous peoples and local communities did not have the benefit of free, prior, informed consent. The indigenous peoples and local communities were evicted unceremoniously without being given notice. Their houses were torched, as is evidenced by the picture you see, and livelihoods were destroyed. They were left destitute. A few of them were settled by the church, who built them iron-roofed houses, which they were not used to. They are indigenous peoples. They have their own way of life. And every time it rained and there was noise of iron sheets, on the iron sheets, they would get very scared and they would run out of the houses because no one prepared them. There was a gross violation of human rights. There was no compensation. There was no resettlement. And besides, the carbon payments fall far too short of the value of other land uses. Not to mention that we are required, the agreement spelled out that we could go to the forest and harvest a handful of herbal medicine and a headload of fuel wood. I mean, this was our forest. So when I come to what it was attributed to, the causes of all those challenges, as I've mentioned, there's power imbalances, stakeholders versus rights holders. The rights holders did not have what it takes to bargain with the with the World Bank. It was all spelled out in the document. But how many of the rights holders were educated, could decipher the legal implications of cleverly written agreements where the World Bank could easily jump off the hook. The World Bank exhibited a short attention span. I don't know whether I'll walk out of here and be arrested for someone said I shouldn't mention who, but okay. It exhibited a short attention span. Hardly had we rolled out the project than they decided they didn't want it anymore. So they passed us on to another person who had not negotiated with. Before we knew it, the National Forest Authority was informing us that our carbon credits would be paid for by someone else. And then, of course, the low capacity of rights holders to invoke the law. So what do we propose? A lot of people have said a lot of things. They say have a long-term plan, not just, a short project. Let it go on for years until it yields results, because impacts are long in coming. Then address the structural barriers, education of stakeholders, for instance. Take the trouble. If they can't read and write, produce materials that have pictures. Get people who speak their language to pass the information. And then start at the beginning. I call it the beginning, which others call the end. Resettle and compensate the indigenous peoples and local communities before any work begins. Then we can be sure that you are going to do it. Then lastly, polluters must just stop polluting. No amount of carbon offsets will address climate change. It's a false solution. Let's face it. Thank you very much.
Thank you so much, Gertrude. And I do think that we can see a lot of the themes emerging and similarities between the cases. And so next we're going to turn to Isa Mulder from Carbon Market Watch to talk about some of those provisions that should be in place before projects go ahead, specifically a grievance mechanism. Isa?
Yes, thank you, Kelly. Let me lower my chair. I'm too tall for this. My slide should be next, I think. Okay, minor hiccup. It's in the presentation. Sorry, minor hiccup. Okay, I'm just gonna start without, and if it ends up on the screen, that would be nice, but if not, also no problem. So Yeah, I wanted to start by saying that these stories that were shared by Judith and Gertrude, they're not exceptions to what's happening to current practices. They're quite the norm at this moment. So you might have all seen stories from the voluntary carbon market of a lot of human rights violations that have been happening recently, but also in the past. We've been seeing stories about human rights abuses, about sexual abuse, about evictions, and other very serious rights violations. And it's therefore absolutely essential that Article 6 learns from these horrific cases and also from the lessons from its predecessor, the CDM, and that Article 6 puts human rights really front and center. And it should go without saying that projects that violate human rights, they have no place anywhere, whether under the Article 6 market or on the voluntary market. And in order to ensure that doesn't happen, first and foremost, projects need to have strong and rights-based safeguards in place before any activities take place. And there are many elements to ensure that human rights are upheld. As Judith and Gertrude already mentioned, there's consultation, there are the Cancun safeguards, and I'm going to speak to another element specifically. Erika will later complement me with more elements as well. I want to speak about grievance mechanisms. By themselves, grievance mechanisms are definitely not enough to ensure rights are upheld, but it's an essential mechanism to allow rights holders to seek remedy after they've experienced any negative impact from a project. And in a way, a solid grievance mechanism can actually also help to deter rights violations because they create a disincentive for harming rights. So some of you might be thinking, what is a grievance mechanism? Or maybe you're all grievance mechanism experts, I don't know. But what it is, it's a formal complaint process that can be used by anyone, individuals, workers, communities, as well as civil society organizations that are negatively impacted by a project or an activity. And this is not limited to carbon markets. These grievance mechanisms are found everywhere for many different activities and businesses. To know what a grievance mechanism should contain, it's important to look at what's out there now, because there are many grievance mechanisms in existence already. And Article 6 should learn from both the good and the bad practices. So Carbon Market Watch earlier this year commissioned a study to assess the robustness of grievance mechanisms on the voluntary market that are out there right now. And we analyzed 5 of the biggest carbon market standards. And it was found that the majority of the grievance mechanisms, that they came with serious shortcomings. So there was only one standard actually that actually has a good... Oh, perfect, it's here. Okay, let me just click through. Oh, if anyone wants to scan this for the study, then I'll stay here for a bit. Yes, so... Oh, sorry. I'll stay. Yemi, you okay? Okay, so yeah, there was actually only one standard that had a decent or good grievance mechanism in place. There is a standard that actually has no grievance mechanism at all, though it is in their work plan for this year or the next year. And many of the major players on the voluntary market have serious shortcomings. There's also an example of quite a good grievance mechanism, which is the Green Climate Fund, but this is not a market standard. It's actually a climate finance mechanism from the UNFCCC. And it's of course very troubling that this is the current state of the voluntary market, that we have to say the majority just has serious shortcomings. So how do you even come to define what is good and bad in grievance mechanisms? How did we assess this? There are criteria by which to assess it, and they are basically the essential elements of on which any grievance mechanism should deliver. And these sometimes go by different terminology, but broadly speaking, they are accessibility, transparency, predictability, independence, adequacy, and protection. And I'm going to talk a little bit about all of them, what they mean. So for accessibility, it's really important that a grievance mechanism is accessible. There shouldn't be a threshold to access the grievance mechanism. So all information should be publicly available. People should know where to access the grievance mechanism. And it should be actively, not just passively, communicated to communities in their language by means that actually reach them in a way that they can actually use the mechanism. And to illustrate this, I'm just going to link it to the situation that Judith described in her presentation, because you also saw in a picture there was a letterbox, and she also said people could send messages. But many people in that community, they couldn't write, so there was no way for them to actually access the grievance mechanism. There was no other way for them to file their grievance. And also, in terms of accessibility, some grievance mechanisms have fees. So you have to pay to file a grievance. This is, of course, a huge deterrent. One of the mechanisms that has that is Vera, though they do pay you back if your grievance is found valid, but still a huge deterrent. So then, transparency. It needs to be possible to see if a grievance has been filed. You need to be able to trace your grievance and where it is in the process. And this needs to be accessible not just for the rights holders, but also the broader public. There needs to be public scrutiny of this process. Then predictability. A grievance mechanism should have a detailed, step-by-step description of how these grievances will be addressed. And there should be indicative timeframes, and this should all be, of course, also communicated in an accessible way. So people should know, like, what's going to happen when I file this grievance, when will I hear back. Then independence. A grievance mechanism should not be guided by any other interests. It has to be separate from the people that are implementing a project. And to link it to the project that Gertrude described, actually there you had to go to the National Forest Authority to file your grievance. But this was one of the actors that was implementing the project. So clearly they're not an independent body. They have a stake in the project. And then adequacy. Turning to a grievance mechanism should actually make something happen. It should have teeth. Filing a grievance should come with consequences, some form of remedy that actually addresses the negative impact that occurred. And then protection. This is about ensuring that there's no repercussions from filing a grievance. For example, by ensuring the confidentiality of the person filing the grievance. And in the Bakassi project that Judith described, there was no confidentiality ensured, and this is a big deterrent because people are afraid of repercussions from filing their grievance. And then on top of all these criteria, the way a grievance mechanism is developed is also very important. The procedure. Rights holders, local communities should be involved in the development from the start, not just as an afterthought. So what does this mean for Article 6? Well, Article 6 needs to uphold human rights, not as an afterthought, but as a prerequisite. And as it's possible to do that now, that needs to be done. If the voluntary market tells us anything, it's that a grievance mechanism is absolutely necessary, as we see from all the rights violations. And having all the necessary elements, including but not limited to the grievance mechanism in place to ensure this to happen, needs to be done before the projects are registered and before credits are issued, not afterwards. All right, thank you.
Thank you so much, Isa. And picking up on a lot of important points connecting the different cases we've heard about and sort of how far short the current voluntary mechanisms are falling. Now we're going to turn to Erika Lennon with the Center for International Environmental Law, who's going to share a bit more on markets generally and also connect these incidents to what's happening right now in Article 6 negotiations.
Thanks, Kelly. And thanks to everyone who's gone before me. You make my job quite a bit easier. And so I think, you know, what we've heard across the board, and the information we've heard from Judith and Bryce and about what's happening in the DRC and Gertrude in Uganda, and that Isa mentioned is happening all over, and it's not new. These are, while there are new things coming out right now, you know, whether they're sexual abuse happening in Kenya, the Ogiek people in Kenya being displaced for potential coming forest offset projects, benefits not going to communities in Zimbabwe. This have happened all over. So we've seen it for years with dams that were under the clean development mechanism displacing people, destroying livelihoods, impacting food, impacting water. So they're not really new problems, even though many new things are coming to light, especially as we're seeing more and more sort of emphasis put on the carbon markets. And just to take a step back, we've heard a lot of reports, we've seen a lot of reports this year about human rights abuses and about the failures of carbon markets. But fundamentally, you don't really need any of these reports to understand how human rights are incompatible with carbon markets and with offsets, because they don't go together. Because if you think about it, and as I think, I can't remember exactly who mentioned it beforehand, it gives a license to pollute. So the notion behind offsets are that you are allowing for pollution and carbon emissions or CO2 emissions or greenhouse gas emissions in one place to be offset by things happening elsewhere. And so we call them carbon credits. They're probably better named as polluter credits or pollution credits, because what they mainly do is oftentimes perpetuate emissions. Because if what's happening is you're allowing companies or countries, largely in the global north, to offset what's happening by funding a project or some activity, largely in the global south, and those are just offsetting what's happening, you're not actually reducing anything. You're not reducing emissions overall. You're just trading where those emissions are taking place. And so that's not going to get us to 1.5. I mean, I think we even hear this from negotiators in the room who are talking about Article 6. They know that we cannot offset our way to below 1.5. And yet we continue talking about these. And I think that one of the core things, and I think that I think maybe Judith touched on this in her presentation, is that it's also not a one-to-one substitute. And so if you think about it, and when you're looking at it, the idea that a land-based, in particular, that a land-based removal could offset a GHG emission, it's just a false equivalency. The land-based carbon cycle and the fossil fuel carbon cycle are not the same, and the timescales aren't the same, and they're not sequestering the same way, and there's sort of a temporal equivalency, and there are much brighter scientists than I am who have written papers on this and that I largely rely on. And I think that, we also, I think this has been shown also through IPCC reports and other things, and I invite you to look at it. And so one of the many things that we're sort of seeing is that it's really, buying offsets or buying carbon credits is really shirking the responsibility. And shirking the responsibility of those most responsible for the climate crisis to actually take the action that's needed. We know, I'm under no impression that this is easy, right? Like we live in, a world that is largely built on a fossil economy. It's not easy, but it's something that we have to do because we all live on the same planet, and it's not going to be a livable planet if we continue, if the climate crisis continues. And so we can't sort of shirk this responsibility. We really have to take the hard steps. We need to take the steps to abate emissions. And I think that, we've seen this year, in addition to the sort of human rights abuses from various carbon market projects, we've also seen a lot of studies, whether they're from, UC Berkeley has put out studies, The Guardian has done studies, Corporate Accountability has done studies, also showing not just the human rights abuses, but the fact that the credits that are being generated are not actually real, and that they've largely haven't produced the amount of offsets that they're claiming. So in addition to not really being able to offset our way below 1.5, we're allowing pollution, offsetting with things that aren't real, and thus emissions are likely going up, not down from these projects, which obviously is a problem. And so that brings me a bit to sort of what's happening here and in the negotiations here. So on the table, and I'll largely talk about sort of what's happening in Article 6.4, on the table is sort of two documents that will help operationalize this mechanism, both on methodologies and on removals. And there are significant problems with both of these. And so right now the supervisory body is also, or the negotiators are talking about what guidance to give to the supervisory body to try and alleviate some of these harms, because the rules, modalities, and procedures for Article 6 do require compliance and consideration with human rights, having stakeholder consultations, and notably having a grievance mechanism. And some of what we're seeing, and one of the problems with sort of going forward with the recommendations, is that they don't have in place all of the standards yet to protect human rights. And so they're in the process of developing a sustainable development tool. They're in process of developing a grievance mechanism. And neither, I would say, at this moment, are quite up to snuff on being able to prevent really the serious abuses that we're seeing. And they're not finalized, and there's still room there. But also, they're considering, sort of adopting these documents here that they say will operationalize the mechanism. Well, one of the very key fundamental things that needs to happen is that before you operationalizing the mechanism, before you start having activities going through the mechanism, you really need to have in place all of these things to prevent harm, so that we're not operationalizing something without having in place the tools to really stop these human rights abuses, to stop harm to the environment, because no one wants to see climate action that is that's harming people, that's harming communities, that's harming the environment. That's not a trade-off we want to see. And that they have in place an adequate grievance mechanism. And so that's fundamental to happen before they can really do anything. And so one of the things that many of us are advocating for here is for that to be in whatever they adopt here, is that the supervisory body needs to finish developing these tools, and that those all need to be in place before any activity can go forward. And on sort of the sustainable development tool itself and on the grievance mechanism, I think Isa laid out quite well all of the principles that need to be in a good grievance mechanism. Having looked at the proposed grievance and appeals mechanism for the Article 6.4 supervisory body, it does not encompass really any of those. It doesn't really look much like a grievance mechanism that we see in other places. I think Isa mentioned, charging fees as one of the things. One of the suggestions is that it will be $5,000 US to file with the grievance mechanism. And they have put in, a potential exception for Indigenous peoples, and that maybe there will be exceptions for others on a case-by-case basis. Well, I don't know how many people in this room could really pay $5,000 to file a grievance, much less communities who are being harmed or displaced from their land. by one of these projects. And so there are really fundamental problems with this grievance mechanism that need to be fixed to make sure that it is accessible, that it's legitimate, that it's effective for dealing with these harms. And the same is true of the Sustainable Development Tool, which is under development. Part of it looks largely like a sort of checkbox exercise. And I think what we've really seen with a lot of these scandals is that it wasn't that, you know, in some of these instances, there weren't policies in place, but in some there are, right? So like some of these, and even the sort of best standards that we have in some of the voluntary markets, or quote unquote best standards, we're still seeing these happening in projects, right? We're still seeing, even with things like the Cancun safeguards or those things, that these are still happening, and they're just not being sort of identified. And so I think that one of the things we really need is for it to not just be a checkbox exercise, and to really take to heart the fact that if you're going to have these projects, you need to have in place rights-based, rights-compatible, really social and environmental safeguards to prevent this worst harm. And not only will it prevent harm, it will also lead to better climate action and better benefits. And I think that one of the things that was highlighted, I think at least in the study around the South Pole and the Kariba project in Zimbabwe, was that benefits weren't going to the communities. So we keep hearing that we need carbon markets, and that's a way to generate climate finance, and this is really what, you know, largely the global South needs. But the benefits aren't going to the people who need it. The benefits are largely going to consultants or to developers or to middlemen, and that needs to be. That needs to not happen, obviously. And I think that one of the things we see is that, you know, in addition to making sure benefits go to people on the ground, that one of the most effective ways of having climate action is to really take rights-based approaches. And this isn't just, you know, a bunch of us sitting up here from civil society organizations or from local communities that I'm sure, you know, some are skeptical of. The IPCC has said this, that more effective climate action is action that is human rights-based. And so that's some of what we are looking for here. I will say that I think, you know, currently, right now, in a room over there, negotiators are talking about this text that I have in front of me. And I think that, you know, one of the things that will be really important and really a litmus test of sort of if they're serious about this and not really creating a system and perpetuating carbon markets that allow for offsetting, which I will say is currently in this text, and it's many of the negotiators have questioned why the word offsetting is in this text, because it's nowhere else and it shouldn't be. But if they're really serious about it, you know, in addition to really putting serious parameters on what's allowed and on not having offsets, they also need to make sure that there are in place, you know, human rights-based safeguards. They need to make sure that a sustainable development tool is developed, that these safeguards are in place, and a grievance mechanism is in place, among a host of other things to prevent, you know, really serious, you know, risks of reversals and other things and rules around monitoring. But that's really key to having in place before any activities can take place. Otherwise, we really risk sort of blowing through any hope of keeping global temperature rise below 1.5 and really undermining the integrity of the Paris Agreement. Thank you.
Thank you so much, Erika, and to all of our panelists. We are going to take questions now from the room. Okay, good, because I was going to say I can't really see all of you, but
This is much better.
okay. So if you've got questions, please put your hands up. Okay, we'll start here. We've got several.
Hi, I'm Katerina from Human Rights Watch. Thank you so much for all these really insightful presentations. I wanted to ask about the, I guess the methodology of evaluating the grievance mechanism. It's probably a question for Isa, but also I'm happy to have thoughts from others. And you explained that very well in terms of, you know, what are the criteria. And one thing I was wondering if, especially for the grievance mechanisms that exist, that you, with this methodology, kind of ranked as good or better than others, to what extent are there also case studies of how they actually play out for people? Because I think some of the criteria, you know, they could meet them on paper, but how much do we know about what's actually happening and if people have been able to use them and how and what the impact of, also what then the results have been if the, you know, if there have been complaints and what the kind of responses have been.
Yes, thank you. That's a great question. And I think that's exactly why you need both, right? You need these assessments on the level of what's in place, but you also need to know how does it play out on the ground. And that's why we need studies like the study that Judith described, where they actually go and see what is happening on the ground. Because, yeah, just what's happening on paper, it won't tell you enough. So that is definitely needed to complement.
I mean, I'll just add. I think that's right, and it's hard to know. And I think while there aren't as many examples from market mechanisms, there's a 30-plus year history of examples from international financial institutions and things like the Green Climate Fund. And while markets, as I've said over and over again, is not climate finance, there are some similarities between them. And I think what we've seen is that it's really hard, and that there are the effectiveness criteria which ISA laid out that come from the UN Guiding Principles on Business and Human Rights, and standards and things I think we've seen and sort of drawn lessons that like people who've worked a lot with communities, particularly in the context of accountability mechanisms, have sort of said like, okay, well here are elements that you need in place to make these effective, but even still, I think we see like even when the mechanisms are good or things sort of go right in the mechanism, actually realizing remedy is quite hard and quite difficult to achieve. And so there's definitely more work to be done even when you have the most effective policies in place.
Okay.
Hi, I'm Catalina from Go-to-Market. Today in the one of the IETA panels, they were talking about the core carbon principles and all the anchor-up principles. And someone pointed out that one of the big things that is missing is, of course, the social safeguards, kind of the social part of it. And so far from everything that I've read about it, it hasn't really included agreements mechanisms or more human rights in general. So I know it's shifting away a little bit from the conversation on Article 6, but I was wondering if if those conversations are also being had in kind of this other setting of the principles that are being followed. Because I do think that it needs to be included. I just don't know, because one of the answers was, yes, but since when we're ensuring, let's say, that financially people are being compensated, that might be enough, but of whether, kind of what form could it take that they could include it in a way that can be generalized for more types of carbon credits.
I actually don't know that much about the mention of social safeguards in the core carbon principles. Wait, because there are none, right?
Right.
Yeah, no, that's the
Yeah,
thing,
yeah,
that there are none, and
Yeah.
whether then,
Yeah, I mean, I don't know that much about necessarily the core carbon principles. I mean, I think that one of the things is that it's sort of fundamental that there should be, and I think that without them, it makes it that much harder for, ensuring that communities and people don't face some of the harms we see, but also like impacts on their water supply, on their, ability, their right to food, or their, right to, traditional cultural knowledge and other things. And so I think there should be, and I think that, one of the things that is often said is sort of like, well, if we have in place, all of these safeguards, somehow it's going to, it's going to be like too prohibitive, or it's going to cost more. But that's somewhat ridiculous, because the people arguing that it's going to cost more, often have significantly more resources than the people who are being harmed. And so what you're saying is that the people being harmed aren't worth as much as, that it will take longer. It also can lead to delays in projects, right? So like if you don't have in place, policies to say get free, prior, and informed consent, or talk to stakeholders, you're much more likely to face, protests, delays, people harming, and so like if you're looking at it from a purely bottom line standpoint, like that's not really effective. And so I think that really people need to focus more on what benefits they give, and that, that if really what you want is effective climate action, you need to have in place standards that really help, that ensure that while taking climate action to reduce emissions or to mitigate, you're not causing other environmental and social harms.
Yeah, and I think that speaks to the not checkboxing exercise as well. So I think we had the, in the front, and then we can take two at a time. So let's say green dress in the front, and then the woman in the red.
Is this on? Just a couple of questions. First of all, just wanted to know whether there may be any examples that could be taken from the bilateral 6.2 agreements till now, if that may at all inform on the discussions that are going on regarding the carbon markets, the voluntary carbon markets, and then also I wanted to know what sense you're getting in terms of the preparation of the negotiators going into these discussions. Whether there's what I'm getting when I asked a few of the countries involved is that it's very technical. But I'm just wondering, like, how much understanding is there precisely of what's involved, both from the human rights perspective as well as, basically what's being proposed versus what needs to be done.
Do you want to start?
Well, so the thing is with Article 6.2 that it's bilateral, right? So it's party driven. And so it's up to parties to decide what's in place. And it's not top down like for 6.4 where there's an independent grievance mechanism. So I haven't read the part of the initial report that mentions a grievance mechanism. Have you, by any chance, Erika?
I have not, and I don't have any good examples from bilateral agreements. I do know that like some of the bilateral agreements that were coming in largely, I think before we actually adopted the rules under Article 6.2 in Glasgow a few years ago, I'm pretty sure at least some of the Swiss agreements have reference to human rights in them, I think, from what I remember. And I think, I can't speak to the preparation of the negotiators going in. Obviously, I think, a lot of these negotiators have long been the negotiators in the sort of carbon market room and have experience. I don't think that necessarily means they have experience with human rights law, with human rights standards, and I think that oftentimes there's an excuse that it's super technical and like there are all these really technical things, but if we're talking about human rights and social safeguards, we're talking about people. It's not as technical as I think we think, or as it's portrayed, and I do think that there could be value actually in some of the people in the room really having more of a background in human rights or understanding more about grievance processes, because I don't think they necessarily do, and I think that to some extent shows in some of what we're seeing. I think in the grievance tool, it doesn't really look like what a grievance tool looks like if you have experience in such things.
Well, just to add, it's very easy to sort of make mechanisms as technical and as confusing as possible, but the thing that we're talking about is actually quite simple at the core. And though even, that doing it on the ground is sometimes hard because you're dealing with a large community and there's language questions, but that doesn't mean that there aren't ways to do it and that we don't overly complicate things in this space when we're so removed from what's actually happening on the ground.
Yeah. Thank you. Can you see? Okay. And like I alluded to power, I did allude to power imbalances. Communities, for instance, are largely not educated. This is a top-down approach. People approach you from air-conditioned, oak-paneled offices. They have no experience of forestry or how you relate with your forest. They approach you with cleverly worded agreements, and then soon, they make you enter into an agreement. They do not, if they can come and touch your houses because you didn't leave at the time you're supposed to leave, when the consultations were not extensive, shows you how much value they attach to the rights holder. So there are lots of power imbalances. There are grievance mechanisms written in the agreements, but they know very well that if they're at the National Forest Authority headquarters in Kampala, and you are in Kisoro, which is like 500 kilometers away, you don't have transport. They have four-wheel drives. They have helicopters. They have everything. They can come to the forest, but they don't want to come. So they know that you don't have money for transport. You have no money to stay in a hotel. To activate that grievance mechanism, you don't know the language they are talking to negotiate. Even your own government is speaking in that language in English. So there are lots of power imbalances within the structure. Structural power imbalances. So it's a very difficult situation. Yeah.
And if I can just add something, like I think it's that's why it's very important to have the study, like environmental and social study for this kind of project to better understand the needs of the people on the ground and try to propose some mechanism which are really like adapted to their needs. And so yes, I think this part of the study is also really important.
Okay, we can take a couple of questions maybe together. So there was, let's start there and then.
Thank you. Yves Lador from Earth Justice. I have a comment and two precise questions. The comment is when we were negotiating the Paris Agreement in Paris, I remember that we were already saying, we're hoping that with Article 6 we're not going to add human rights violation to the one already existing because of climate change. So now you have two layers, the human rights violation because of the climate change and the layers of human rights violation because of climate action. That's where we are today. And actually recently with some friends from the UN, we were reviewing a bit randomly a number of these projects and so on. And we got to some kind of a new categorization because some of them are just purely fraud. They buy credits in the country. Nothing is done in the country. They just measure the trees, which already exist. And from that, they draw the credits and sell it. But what happened in this analysis is, okay, this is just fraud. But you have another category where you have fraud plus human rights violation. So in a way, we found ourselves, okay, fraud, that's not such a bad news. It's just fraud. You don't have more people displaced. You don't have more people in the jails and so on. So this is a bit of a new discovery for us in terms of human rights categories. It's improvement, of course, from the climate action. Now, coming from a country which is a champion in Article 6 too, which is precisely, Switzerland with the different projects, I have two very precise questions. Do you have, among the different NGOs working on that, some kind of a mapping project or an overview of these different impacts? Because that's one of the issues we have a lot coming from the companies and so on when we talk about it. So, that's just one example, Yeah, you might have a mistake here. And you'll have this repeatedly when we basically have the sense that this is more systematic. And I think this is something we need to document. And my second question is, do you have any good practice example? I haven't heard or read of any in the literature, but it's perhaps because I didn't, study the issue seriously. But in other places we do have, the good practice. Usually you have two or three, everybody's repeating, and you use them. And here it seems there's not even one good practice. But perhaps I just missed it. So if ever you have it, I'll be very happy to discover it.
let's take a few at a time.
Hello. First, thank you very much for the panel. My question is about the ongoing negotiations on Article 6.4. So could you tell us maybe what are the positions, the oppositions, what is discussed, and what are the different points of view? Thank you.
Okay. Why don't we just go down the line?
I will try. I'm going to go with, I personally don't have any good practice examples, so I'm going to answer that one first. Yeah, I mean, I think we often hear the sort of like, but you've chosen like 3 examples of bad projects. And I think that and just because we don't know, or just because they don't come to light, don't mean that they're not happening. It may just be that, there were, I think the most recent report from SOMO that Isa mentioned on sexual abuse in a Kenya project, it's been going on for years. Just no one knew about it because no one reported anything about it and no one really looked into it. And I think that's part of it, is that like people don't look into it, or when they do look into it, or the people sort of verifying it say, yep, fine, it's all good. We just don't see them because, they're not happening in our backyard. They're happening somewhere else. And so I think it just sometimes takes time to come to light. And I think that, we've seen years of sort of these things happening over and over again. And, I think, a number of us have done studies about different projects. And I know Carbon Market Watch has done numerous reports on sort of like, here are different communities that have been impacted. And some of it's just about, being able to connect with those people and getting those stories and connecting them to this broader, to the broader sort of discussions that are ongoing. And on the ongoing negotiations question, that's a big question. There's a lot of different opinions and different things on different issues. I mean, I will say that, we've seen, I'll go with the sort of on the recommendations on removals, because that's a lot of what I focus on, or on activities involving removals. I think we saw a number of parties not totally happy with what the supervisory body came up with. I think that included the EU, it certainly included ILAC, the group of Latin American countries. It included, I think,
AOSIS.
What? AOSIS, the Alliance of Small Island States. I think a number of countries, including New Zealand and Canada, have highlighted some of the, really stressed on sort of some of the human rights aspects and the grievance mechanism and the sustainable development tool. Whereas we've seen other parties, say it's not perfect, but, we need to move forward with this. So it's a bit of a mixed bag, but I'll stop talking because I've been talking a lot.
You've been talking a lot, but you've been saying the right things. I think that's a pretty comprehensive overview. I think it's a sad truth, but it might be necessary to indeed have some kind of repository for these case studies, so that it's not just set aside as like one bad case example. I don't know if Human Rights Watch, that's something you want to collab on, but very open to this idea, if it doesn't already exist somewhere.
Yeah, thank you very much. I think I'll just concentrate not on what's happening with Article 6, but I'm going to concentrate on whether there's no good practice. Well, whatever would be a good practice is overshadowed by the bad. And we must keep in mind that this is a chain of command. Whatever good practice there is, for national civil society organizations I mentioned, which are based in town, and they're invited to consultative meetings, and they are given heavy per diems, well, that is a good practice. But for the rights holders who are evicted, whose houses are touched, that's not a good practice. It doesn't matter what intervention you bring. As long as you throw me out of my home and you don't compensate me, it's a bad practice.
Judith, do you want to add anything?
No, I was mainly focused on the Congolese case, so it's not a really good example of good practice, and sorry.
We have lots of examples of bad practices. And I do think that at some point, while much of this research focuses on either a specific case or a specific mechanism, at some point you have to start taking the totality of evidence as that this is not just a few bad apples. Okay, we will take one last round of questions. Yes, you've had your hand up, and then so the gentleman in the blue shirt and the jacket in the back, and then the gentleman in the green shirt, I think, in the front. Yeah.
Asim Zia, Professor, Environmental Policy, University of Vermont. I just want to draw back to the Paris Agreement question that at that point of time there was a discussion in environmental policy theory. It's very well recognized that a carbon income tax, carbon trade tax internationally would be way more efficient and with safeguards embedded into them, like fair trade mechanisms. That would be actually have less transaction cost, but also be more respectful and more efficient. So I'm wondering, why don't we just abandon these market mechanisms? Because carbon market, Article 6, because I think I don't see that any lesson has been learned from the CDM or RED Plus in terms of the additionality, leakage, social safeguards. And on top of that, what we are hearing about these human rights violations, that's really disgusting. So I'm just wondering that, in terms of, is there any discussion even about the floor for the market, like minimum floor price? Because when you set up the tax mechanisms, for example, you can embed those differentials in the sense of say, okay, you need to internalize the cost of human rights violations, internalize the social cost of carbon into your price mechanism. And I just want to make one more comment that I think when we sell cheap carbon market credits to the developed country industrialized firms, we're basically abetting the carbon criminals in terms of making them do more of what is needed not to happen more. So I'm just wondering I'm really kind of interested to hear about your perspective on some of these questions that I raised here. Thank you very much.
Hello, my name is Zhong, and I'm from Carbon Cano Lab in Hong Kong. And so in Hong Kong or in many other places, there are lots of companies that rely on the carbon credits to offset their greenhouse gas emissions and take the checkbox for the climate action. But my feeling is that basically they are not aware of the problems of the carbon credit market. And so I would like to ask, what should we tell the companies who rely on the carbon credits about what they should do? And my ultimate question is, are there any ways that the market or the system can still be improved, or we should say we should totally abandon the system? And this is my ultimate question.
Those are some big questions and maybe good ones to end on. So, do you want to start over here this time, or
about the Paris Agreement, maybe you can answer.
Yeah. Okay. Well, I will say maybe I'll start for a second, and then so just that because we ask that question too. Why are we still here talking about carbon markets again? And I do think that one of the reasons, and Erika touched on this a little bit, is because of the lack of public climate finance. And so, I mean, for a long time, we've been seeing a push from people who are looking to buy offsets because they don't want to do their mitigation internally, whether it's a country or a company. But I think we're also seeing now is that the sort of failure of public climate finance thus far has meant that there are plenty of developing countries who are really looking for support wherever they can find it, and right now the only ones knocking are carbon credit markets. But as Erika pointed out, this is not, carbon markets aren't climate finance. Not only are they then selling a sort of right to pollute, they're also generally not getting the benefits that they actually need to do the types of transitions that we need. But I do think it's going to be really hard to get in front of that without providing actual climate finance from the Green Climate Fund, from the New Loss and Damage Fund, from the Adaptation Fund. And so I think that we're really going to have to wrestle with that, both as civil society and as governments. And maybe I'll leave it there and see if either of you have something to add.
I mean, yeah, I think there are often discussions around the social cost of carbon, and obviously, like if you're thinking about the cost of carbon, whether it's a credit or anything, it naturally should take into account the sort of the broader social cost. I don't know that that's discussed as much here, at least not sort of to my knowledge, and I think that's on the question of what should we tell companies and companies that rely on carbon credits, and should we just abandon them? I think my answer is yes, we should, because not only no matter how many different standards that have been developed thus far, no matter how many efforts there have been to create more integrity in the carbon market, or make carbon credits excellent, it hasn't worked. And it's not new. These aren't like, as you mentioned, we haven't learned the lessons from the CDM. We sort of think we have, and instead of calling it the clean development mechanism, we put in things around sustainable development. But there's no evidence so far that we're not just repeating those same mistakes. And so I think that I do think that, there are over and over and over again attempts to sort of make better carbon credits and to see like, oh, well, if we just put in these standards, they'll have more integrity, whether that's from an additionality standpoint or an emissions reduction standpoint or a human rights and social standpoint. And it largely hasn't worked. And so what really needs to happen is that companies need to reduce their emissions. That's what we need to do. And we know that. And I think that the other thing, and I think Eve, you touched on this in sort of thinking about it, is that in addition to sort of the human rights problems or the fraud problems of the credits themselves, we know that if we're not reducing emissions, if we're not reducing greenhouse gases, if we are not having as I think everyone here has heard, a full, fast, fair, funded phase out of all fossil fuels, full stop, no words around unabated, no words about anything. If we don't have that now, we're not going to deal with the climate crisis. And that's what we need. And so perpetuating a system that allows for ongoing, production and use of fossil fuels, most often in the global north, who is most responsible for this crisis, by sort of buying offsets elsewhere, it's just not going to work. We're not going to get there. And so what we really need is that public climate finance. We really need actual finance, and not finance that is allowing for pollution in the north with action in the south, but finance that is promoting action in the south, that's promoting, good action, rights-based action, locally led climate action. So I think if we're looking for good examples, that's what we should be looking for. Solutions that, women on the ground have, solutions that Indigenous peoples have, and not looking for ways to sort of buy our way out of doing what we need to do.
Maybe not to speak to this, but to link it all also back to the negotiations, as was also the question before. If any of you are also very concerned about this, and I get the feeling that people are. So right now, the 6.4 text does not contain a requirement for these elements, these safeguards and this grievance mechanism to actually be finished, to be adopted before any activity takes place under 6.4. So please, if you have any chance of any links to do advocacy work, please use that. Also, if you have input, if you know stuff about human rights, if you know stuff about law, or if you don't, if you just have experience, please make inputs to the supervisory body. They do read everything, they always tell me, on the SD tool and on the grievance mechanism that they're developing now.
And,
Sorry, can I just add on that point? If you go to the supervisory body website, it will suggest that you can no longer submit comments and that the comment period is over. That is not true. They have said that they will still take them. So, as Isa mentioned, please do submit them.
And one other point is to the UN Secretary General's Integrity Matters report on net zero, which sets standards for non-state actors on setting their net zero goals. It's actually pretty clear that companies should not be using offsets for their fair share of effort in this critical decade of between now and 2035. And so that's about as clear of a statement as can be made about what companies should be doing right now. We're closing on time, so I'm gonna give each of our panelists a chance to sort of say one closing thought just about what you hope the takeaway is, or maybe what you hope that Article 6 negotiators are thinking about as they finalize negotiations over the next few days.
So I think it's really critical to have safeguards under Article 6, and as we saw with these examples, Article 6 is not just a technical issue, and we have to make conscious that what is at stake is really, really important for some people, indigenous communities and local communities who are directly impacted by these kinds of projects, and that's why I think it's really, really important to keep in mind that the negotiations around this article are still important to follow.
Thank you. I feel that we have no business engaging in carbon trading. It's exacerbating the power imbalances, the neo-colonial power imbalances, and we should not look for solutions in that direction. Thank you.
Yes, echoing Gertrude, carbon markets are not a climate solution, but I fear we will be stuck with them. And so we have to set a really high bar, especially on human rights, in any way possible.
Yeah, I agree with everything everyone has already said. And carbon markets really are a dangerous distraction. We don't have room. We don't have room for offsets in the world that we need to see. And tomorrow, I will note, is the 75th anniversary of the Universal Declaration of Human Rights. And what we really need across the board, since, as Isa mentioned, Article 6 seems to be here to stay, despite everyone knowing, or hearing, not everyone, but many of us knowing that carbon markets are not the solution. And we need to make sure that all climate action, whether it's in carbon markets, which it shouldn't be in, or elsewhere, is compliant with and is rights-based and is really focused on benefiting all of us. The climate crisis is a human rights crisis, and instead of focusing on dangerous distractions, we need to focus on what we need to do, which is a full, fair, fast-funded phase-out of all fossil fuels.
Thank you so much, everyone, for coming, and have a good evening.
Thank you.
Thanks, Yemi, for coming.
Thank you for coming.
Thanks, Yamba.